Welcome to Think IP, the podcast that helps entrepreneurs, startups, and small businesses turn ideas into assets and businesses into brands. I'm Dr. M, and today we're tackling a critical but often overlooked issue: joint ownership of intellectual property assets. If you're collaborating with a co-founder, partner, or another business to develop a new product, technology, or brand, joint IP ownership might sound like a fair and logical choice. But it comes with challenges that can make or break your business. By the end of this episode, you'll know why joint ownership of IP can be risky if not managed correctly, the key questions to ask before agreeing to shared IP ownership, and how to protect your business interests while keeping partnerships strong. Let's get into it. Before we talk about risks and strategies, let's define what we mean by jointly owned intellectual property assets. When two or more parties collaborate to develop an invention, brand, content, or proprietary method, they might decide to co-own the IP. This means that both parties have equal rights to use, license, or enforce the IP, unless otherwise agreed. For example, two tech startups co-develop an AI-powered customer support bot. They both contribute code, data, and technical expertise. So, they agree to jointly own the patent and copyrights. Sounds fair, right? But here's the issue. Without clear agreements up front, decision-making becomes a nightmare. Challenges in joint IP ownership. Who controls licensing decisions? Can one party sell the technology without the other's approval? What if one party wants to enforce the IP against infringers, but the other doesn't? How do you split maintenance costs? What happens if the partnership ends? These are serious concerns that can lead to disputes, lost revenue, and even legal battles. So how do you avoid these pitfalls? Let's break it down. The best way to protect joint IP is to plan ahead. Before you even start working on an innovation, brand, or content, you need a clear agreement covering these four critical areas. 1. Who manages the IPA? Which party is responsible for the ongoing management of the IP? If one company has more legal and financial resources, it may make sense for them to lead IP protection efforts. But this must be agreed upon up front. Define in writing who makes strategic and tactical decisions, such as filing for patents, trademarks, or copyrights, monitoring and enforcing IP rights, and deciding how and when to license or sell the IP. For example, if Startup A and Startup B develop a co-branded SaaS tool, they might agree that Startup A handles patents while Startup B oversees brand protection. 2. How are decisions made? If both parties wish to be involved, how are decisions made and what happens if no agreement is reached? Decision-making deadlocks are a huge risk in joint IP ownership. Clearly define who has the final say in disputes. Is it a simple majority, or do you need unanimous approval? What happens if no agreement is reached? Consider mediation or arbitration clauses to avoid costly lawsuits. Can either party sell their share? What happens if one partner wants to exit? For example, a biotech company and a university jointly develop a new medical device. They might agree that the university handles academic research licensing, while the biotech company controls commercial licensing deals. 3. How are costs split? How will the costs of protecting the IP be met? IP protection is not cheap. Patents, trademarks, copyrights, and legal fees can add up. Agree beforehand on how costs will be shared. Define what happens if one party stops contributing. Does the other party get full control? Set rules for revenue sharing from monetized IP. For example, two software startups build a jointly owned AI model. One provides funding while the other provides development. Their agreement should outline who covers patent and copyright filing fees and how revenue is split if the model is licensed or sold. 4. Will parties assist each other in protection efforts? Have the parties agreed to assist each other in obtaining protection? Many businesses forget that protecting IP involves signing documents, providing technical details, and getting assignments from employees. Include a cooperation clause ensuring that both parties sign necessary documents for patents, trademarks, provide technical assistance when needed, and ensure that employees assign their contributions to the company. For example, if one startup develops an AI trading algorithm and another startup helps train it, both parties should agree to cooperate on IP filings and prevent employee leaks. If joint ownership sounds too risky, consider these alternative structures. One licensing model. Instead of joint ownership, one party owns the IP and licenses usage rights to the other. 2. IP holding company. Create a separate legal entity to hold and manage joint IP. 3. Profit sharing agreements. One party retains ownership while the other gets a percentage of revenue from monetization. For example, instead of co-owning a patent, 2 AI startups might agree that startup A owns the patent and startup B gets 30% of a licensing revenue. Final takeaway: set the rules before the game starts. The biggest mistake in joint IP ownership is failing to agree on the rules up front. Your next steps. If you're considering joint ownership of IP, draft a clear agreement as soon as possible. Answer the 4 key questions we discussed. If you're unsure, talk to an IP attorney to avoid future legal battles. Remember, great partnerships build great businesses, but bad IP agreements can destroy them. Protect yourself, protect your ideas, and build a future where your IP works for you, not against you. Have you ever faced issues with joint IP ownership? Drop a comment below. I'd love to hear your thoughts. If you want to dive deeper into today's topic, hit that subscribe button and I'll send you a free copy of the Think IP book. Over 300 pages of practical, high-value insights. And if you found today's discussion valuable, share this episode with fellow entrepreneurs and business leaders. Until next time, think IP because it pays.